request for stipulated facts.
I don't know what that is. Stipulated facts. What do you mean by that?
I made a judicial notice over the facts of the case of what I was trying to get straight with prosecution, and none of those questions were answered as far as the legal terminology that we're using.
So what they're charging you with? Or what is it you want from the prosecutor? Okay, so Mr. Valentine, here for confirmation of that jury trial that's scheduled for the 18th and 19th. So the question is to everybody, I see that you filed several motions, had a time to kind of look at generally, looks like there are some motions about evidence in there that need to be heard at the time we start trial.
Mm-hmm.
So we'll do that. Otherwise, all the rest we'll just hear the day of trial, get that figured out. Are you prepared to go to trial on the 18th and 19th?
No, I'm still waiting for some documents from the Office of Assigned Counsel, a request for stipulated facts, the case transcripts, bonds, and bar numbers of the individuals of the case.
Okay, let me ask you, how is that going to impact your defense at trial?
Because I need to go over the documents and the case transcripts, things that I've submitted and things that have been done by government officials in the case previously.
But what does it have to do with your defending against the charge? That's what I'm trying to figure out. So that may be something that you want to, I'm not sure what you want to do with that. If you're thinking that there's governmental misconduct or ineffective assistance of counsel, or you want to make a bar complaint or something.
All of the above.
Yeah, that doesn't impact the issues as to bringing a trial forth on the charges.
Well, it does, because I'm going against the state, and the state's governmental misconduct is a direct effect of how the case is turning out.
Okay, so let's put that aside. Would you be ready to present your defense?
Once I get those documents, I will be able to.
Okay, all right. And so those documents would be transcripts of the court records.
Yes.
And
a request for stipulated facts.
I don't know what that is. Stipulated facts. What do you mean by that?
I made a judicial notice over the facts of the case of what I was trying to get straight with prosecution, and none of those questions were answered as far as the legal terminology that we're using.
So what they're charging you with? Or what is it you want from the prosecutor?
There's a judicial notice I made. I'll have to see the transcripts to see exactly what I put on my judicial notice, but the terminology used by the court officials are misguiding. So I was trying to get an understanding with prosecution of what exactly is being meant by the legal terms being used.
Buckle up, guys. Today we're looking at a courtroom moment where what should have been a simple trial confirmation starts drifting into something far more complicated. The judge begins by confirming whether Mr. Valentine is ready for his jury trial scheduled in just a few days. Instead of a straightforward answer, the defendant explains that he's still waiting for a long list of documents, transcripts, bonds, bar numbers, and other records. The judge immediately tries to understand how any of these requests would actually affect the defendant's ability to defend himself at trial. But the explanation coming back is vague and scattered. You can already see the judge trying to bring the conversation back to the real issue, the charges and the trial itself, while the defendant seems focused on broader claims about government misconduct and missing paperwork. Right away, the courtroom dynamic becomes clear. The judge is trying to keep things grounded in actual legal procedure, while the defendant is moving in a very different direction.
I'm trying to figure that out.
For example, like the state of Washington and Washington State being two different things.
Okay, they're not. I see that you may think they are, but effectively in law, they're not. It's not an issue here. Let me just kind of look at some of the things you filed and see. Okay, so, all right, transcript of past hearings, something from the prosecutor that I can't quite figure out. You want information about the previous attorneys that may have represented you for a short
I wanted the communication between previous counsel and the prosecution, the case transcripts, and the bonds on record and oaths of office.
okay, of the oaths of office of the prosecutor who,
You and the prosecutor, and for the attorneys that I previously had.
well, for me, you could just go to the auditor, state auditor, or in the city or the county auditor. They have everything there. Prosecutors, you can always ask the prosecuting attorney's office. I don't
Would
find
the
that.
Office of Assigned Counsel can't provide me with that?
You can certainly, yeah, ask them too. Ask them for their people what they have. I can't say.
Okay,
what
yeah.
that-
I haven't got a response yet. I've sent the email. I've called them and sent the email.
All right. So again, you're representing yourself. Still trying to figure out how those are impediments to.
Because even though I'm
Taking this
representing
to
myself,
court.
the court is still obligated to provide legal assistance.
The court isn't supposed to provide legal assistance to either side of you. We're supposed to make sure things are done right and fairly. I can't assist you in your trial. That would be wrong because I can't assist the state either in their trial.
Don't I have a constitutional right to counsel?
You do, and we did appoint Thurston County Public Defense at one point.
So yes, they are appointed to provide legal assistance for me.
Yeah, and so
When I put in my motion, I said that I didn't want to be represented, but I still wished to have legal assistance.
yeah,
I just
well,
don't want anyone speaking for me.
so you want standby counsel is what we would generally call it. Someone who would pretty much sit in the audience, and if you wanted to step back and ask a question of them, you could ask a question of them. The lawyer from Thurston County Public Defense. That's pretty much the utmost of what a standby counsel does. Is that what you're asking for? Because
I'm asking for legal assistance. It's my understanding that I have a constitutional right to counsel.
sure.
And so I'm asking that the state in some manner provide me with someone who will assist me with my legal affairs. I don't want to be represented or deceived into.
Now, the conversation starts revealing a deeper problem. The defendant explains that he's trying to understand certain legal terminology used in the case and claims the language from the court and prosecution is misleading. At one point, he even raises the argument that the state of Washington and Washington state might somehow be legally different things. The judge quickly corrects that idea and explains that in the context of the law, they are not separate entities. This is also where the judge highlights something important. The legal system uses specific terminology and procedures that people typically learn through years of legal training. That's exactly why the Constitution guarantees the right to legal counsel. But the defendant has chosen to represent himself while still expecting the court to provide assistance along the way. The judge carefully explains that the court's role is to remain neutral and ensure fairness, not to help either side build their case. And at this point, it becomes increasingly clear that the defendant may be trying to navigate a very complex system without fully understanding the rules that govern it.
Taking someone else's opinion of how to handle things.
Well, you don't get to kind of pick and choose how it's done. We've appointed counsel at one point, and you didn't want to do that. I could potentially, and I can't speak for the Office of Assigned Counsel. You know, they're the executive branch government. I don't run their office. I simply find if someone is indigent or qualifies for public defense and say, yes, they can have one, and then that agency takes over. But at this stage, so
When I was made pro se, that is what Judge Brant Buckley had discussed. He said that I wouldn't have counsel represent me,
yeah.
but that I had legal assistance.
By the time we reach this final portion, the judge starts connecting the dots about why this situation has become so messy. The defendant explains that he did reach out to someone from the Public Defense Office for legal assistance, but he hasn't actually spoken with the attorney who was supposed to help him. With the trial date only days away, that raises a serious concern about whether he's prepared to move forward. The judge asks a few more questions and quickly realizes that the lack of communication with that standby attorney is likely the real reason the defendant is not ready for trial. The prosecutor representing the state indicates they have no objection to a short delay, and the judge ultimately decides that granting a continuance is the most reasonable solution. The court will set new hearing dates, review the motions that were filed, and give the defendant time to connect with the legal assistance he requested. What began as a routine scheduling hearing ends with the entire timeline of the case being pushed back, simply because the defendant hasn't yet coordinated with the help that was already arranged. If you found this breakdown helpful, make sure to like the video and subscribe to the channel for more courtroom moments like this. Thanks for watching, and we'll see you in the next video.